We are following developments on that devastating Michigan school shooting still playing out in the court system now 3 years later, as the parents and families of the victims in the 2021 Oxford school shooting are trying to prove school employees were negligent before the shooting. Those families have lost their case in the Michigan Court of Appeals. They will now appeal to the state Supreme Court. The shooting left 4 teenagers dead: 17-year-old Madison Baldwin, 16-year-old Tate Muir, 14-year-old Hannah St. Juliana were all killed at the scene, and 17-year-old Justin Schilling died later at the hospital. 7 more were injured that day. I've spoken with the victims' families over the last few months who say this trauma of the tragedy has stayed with them.
I've held them partially responsible for my son's death since day one. Once I learned about the math assignment and the fact that they didn't take him out of school, they didn't get him any help. It was really a very sad situation on top of an already devastating situation.
The perpetrator, 15-year-old Ethan Crumbley, who had previously sketched a gun, a bullet, and a wounded man on a piece of schoolwork, a piece of paper with several disturbing phrases, had met with the school and his parents about his behavior. Crumbley's parents, Jennifer and James Crumbley, took Ethan's shooting as a pastime, even bought him the gun. Ethan's parents are the first ever parents charged and convicted for a mass shooting their child perpetrated.
He's still strong today. I mean, he wants to work through this, but now it's part of his life, and that life will never be the same.
Ben Johnson, law and expert trial attorney, represents some of these parents, these families, and they blame the school for what happened. He's here to talk about this next move in the court system. Thank you for your time. This is another heartbreaking setback for these families. What was behind the ruling in this case to not go after the school district?
Marty, the Michigan Court of Appeals agreed with trial judge that threw our case out of court and said that my clients don't even get their day in court to try to prove that somebody else other than the shooter could be, under Michigan law and governmental immunity, the proximate cause of this shooting. And we believe that the Court of Appeals got it wrong. They ruled that no reasonable juror could ever come up with or believe anything different based on this evidence. And that's why we believe we have the right to a jury trial. So we're going to go to the Michigan Supreme Court. We're going to ask the Michigan Supreme Court to throw out governmental immunity, where the government is above the law and they say they can't be held responsible when they're responsible for your child's injury or death. We think that's wrong. And we think under these facts, this case should go to a jury.
Based on the evidence that we now know about this tragic case that day and the days and even weeks leading up to it, what is the most damning, and what could and should the school district have done in your eyes?
So much. Their own internal investigation done 2 years later, Guidepost, specifically found the school accountable and said that they made multiple mistakes, that they should have prevented this shooting from occurring. It goes from ignoring a risk assessment sheet where the shooter was identified with a score of like a 30 or 31 when normal is like 15. He was high risk, and they claim that they never even looked at that. That was done earlier in the school year. On day 1 of the school year, he had about, Marnie, the math test where he drew the picture of the gun and so forth. He had done almost an identical picture on the first day of that same school year. That was never passed along to administrators until the day before the shooting on that Monday. He was looking at bullets live on his phone on that Monday. He was absolutely gone through his homework by a number of the teachers, and they tried to move it up the chain to the counselor and say, we have concerns about what's going on here with this kid. And then we know what happened on Tuesday. They ignored every single sign, and just as bad, when his parents didn't take him for help, they should have sent him in an ambulance, sent him for a psych evaluation at an emergency room, called Child Protective Services. Instead of doing that, what did they do? They gave him the backpack that contained the gun with multiple magazines. So they literally gave him the weapons to conduct this shooting without ever searching it, without searching his locker, when we all know they search for kids vaping and cigarettes and pot every day in lockers and backpacks, Marty. So there's no defense to this whatsoever.
Ultimately, what is the outcome your clients are looking for? What does justice look like if the state Supreme Court were to reverse this decision and move forward?
Their day in trial so that everyone can see the mistakes that were made at school, where the school should have done more than they did, call the authorities. How about they had 2 or 3 armed security guards in that school on that very day? How about calling them and coming down and chatting with this kid? How about searching his backpack and his locker? How about getting him mental health help? Call Child Protective Services. There's so many things that they should have done. Full accountability, my clients have said, Marty, from day one. And that goes to, of course, the shooter, that goes to the shooter's parents, but now that goes to these folks at the school and others, I might add.
Well, please give our best to the families who continue to live day to day in this nightmare. And then we'll follow this case closely as we have since the start. Appreciate your time, sir.
Thank you, Marty.